I think all the commission members know that the ethics questionnaire. We'll go ahead and convene a Monday, November 16th, 2020 meeting of the North Carolina Property Tax Commission. Sorry for the inconvenience. We have everybody on now. For the commission members, you have on your agenda a reminder about any conflicts of interest or ethics responsibility. So I assume if there is one, I will call that to my attention. As I mentioned, I would have had one on the Dallas County item on for today, but that has been withdrawn. So no need for me to recuse myself in that matter. The only case that we have on today is from Wake County, Cornerstone Family Church International 20 Property Tax Commission 273. Let me introduce the commission members. Carter behind me is Vice Chairman of the I'm Bob Hunter, Chairman. Alex Guest is to my left, Commissioner and Commissioner behind him, our counsel, Steve Pelfrey, who's on over. And with us, technology today is Alexander Vendette and Anise. What's Anise's last name? Upchurch? Anise Upchurch, who's serving as backup today. And the county today is represented by Ken Murphy, who we've seen numerous times, and the appellant, Cornerstone Family Church International, is represented by John Adcock, who's been here as well, and Linda Garrett, also virtually is our court stenographer. So, looked over the file, and I think we had this matter before us one time on a procedural issue, and so now it's back before us for hearing on the appeal. As I saw in the trial conference report, there's really nothing at issue right now. Everything is stipulated to. The county has no exhibits. The exhibits are, I guess, the charter and the deed and a couple other items for the appellant. There are no witnesses, as I understand it. And this, even though we got a late start, we should be able to handle this one without any problem this afternoon. So, that all having been said, Mr. Adcock, you're the appellant. No need for anybody to be sworn, Ms. Garrett. So, Mr. Adcock will hear from you at this time.
Thank you, Mr. Chairman. As stated, I'm John. I'm getting some feedback. Mr. Chairman, my name is John Adcock.
I'm gonna cut on my mic, see if that helps. Does that help?
Mr. Chairman, can you hear me okay?
We can.
Okay. Yeah. As stated, I represent the appellant in this matter, which is Cornerstone Family Church International. The county and the appellants have stipulated to facts and exhibits, as stated earlier, Mr. Chairman. The factual allegations of the appellant enumerated as 1 through 16 in the appellant's notice of appeal for hearing, submittal, and additional documentation and evidence previously filed with the commission are stipulated to by the parties in the order on final pre-hearing conference. The appellant requests that these stipulated facts be received and admitted as evidence in this case.
So admitted.
All of the exhibits attached to the order on pre-hearing conference, which are identified as exhibits A, B, C, D, E, and F, have been stipulated to by the parties as genuine, and the parties have agreed may be received as evidence in this proceeding without further identification or proof. Exhibit A is the Articles of Incorporation of the appellant, filed with the Secretary of State on July 5th, 2012. Exhibit B is the North Carolina General Warranty Deed, recorded on May 20th, 2019 at Book 17447, page 603 in the Wake County Register of Deeds. Exhibit C is the appellant's application for tax year 2019 property tax exemption or exclusion, submitted to the Wake County Tax Administrator's Office, and has a NCDOR file stamp of February 18th, 2020. It is signed by Sherry Morgan as the administrator of the appellate on January 31st, 2020. Exhibit D is an email from Marcus Kinrod, the Wake County Tax Administrator, dated March 2nd, 2020, to Matt Calabria and John Adcock. Exhibit E is the Wake County Real Estate Assessment Notes for the appellate's property as published on the Wake County Tax Department's webpage. Exhibit F is the year 2019 Wake County tax bill for the appellate's property as published by the Wake County Tax Administrator's Office. The appellate requests that exhibits identified as A, B, C, D, E, and F be received and admitted as evidence in this proceeding.
We'll deem all those.
Thank you, Mr. Chairman. So the facts and exhibits are summarized as follows in this case. The appellate is a North Carolina charitable religious nonprofit corporation. On May 20th, 2019, the appellate purchased real property located in Wake County, having an address of 9725 Fayetteville Road, Raleigh, North Carolina. Exhibit B, the deed referred to earlier, is the deed in which the property was conveyed to the appellate. The appellate purchased the property from a North Carolina nonprofit corporation with the name of Faith Development Ministries, Inc. Prior to the conveyance of the property to the appellate, Faith Development Ministries, Inc. was the owner of and using the property that's subject to this matter for religious purposes, and the property was exempt from taxation. The appellate purchased the property to be used for religious purposes, and the property has been continually used for religious purposes by the appellate since it purchased the property. On the deed conveying the property to the appellate, which is Exhibit B, the appellate's address is incorrect. The address is 5415 Fayetteville Road, Raleigh. That is not the address of the appellate. It is not the address of the property. And to my knowledge, is not the address of the grantor on that deed. After the appellant purchased the property in May of 2019, the county mailed an application for property tax exemption or exclusion to that incorrect address. Because of the incorrect address, the appellant did not receive the application, nor did it receive the tax year 2019 tax bill from the county. In January 2020, the appellant became aware that the county had removed the appellant's property from exempt status. In January 2020, and after it had become aware of the county removing the appellant's property from tax exempt status, the appellant submitted to the county an application for property tax exemption for years 2019 and 2020. The county accepted and approved the appellant's application for property tax exemption for year 2020. The county did not accept the appellant's application for year 2019. Exhibit C that has been admitted is the appellant's 2019 exempt application submitted to the county. Exhibit D that has been admitted is an email from the tax administrator, Marcus Kinrod, to Wake County Commissioner Matt Calabria and myself. It is dated March the 2nd, 2020. At the time of this email, I did not represent the appellant. A member of the appellant's congregation had reached out to me, and I contacted Mr. Calabria at the member's request as an attempt to assist with this matter without representing the appellant. Mr. Calabria contacted the tax administrator, and the email is in response to Mr. Calabria's inquiry. As the email indicates, the county did not accept the year 2019 exempt application based on the county's interpretation of NC North Carolina General Statute 15282.1a. Specifically, the last sentence of that provision, which states an untimely application for exemption or exclusion approved under this subsection applies only to the property taxes levied by the county or municipality in the calendar year in which the untimely application is filed. So under 105-282.1a, you can submit a late application for exemption for good cause, and if good cause is shown, it can be approved by the county. But under the county's interpretation of the statute, the county cannot accept those applications except for the year in which the untimely application is filed for. The content of the email also establishes the county tax administrator instructed the pastor of the appellate to file the year 2019 exempt application with the State Department of Revenue to see if they would accept it. The appellate did file an appeal to this commission. So what the guts of this case is, Mr. Chairman and Commission, is that on January 1 of 2019, and years prior to that, thereto, the property that the appellate owns and purchased in May of 2019 was exempt for religious purposes. The exemption was removed by the county in accordance with North Carolina General Statute 105-285D because the appellate purchased the property prior to July 1, 2019. If the closing had occurred after July 1, the exemption would not have been removed unless the appellate did not apply for the exemption during the year 2020 listing period. On January 1.
Give me that statute again and remove that.
Yes, sir. It is 105-285D.
285D.
D as in dog. Yes, sir.
Okay.
And basically what that statute says, Mr. Chairman, is that when you have a property that was in exempt status as of January 1 and it's transferred prior to July 1, then the exemption for that calendar year is removed. If the closing under the facts that we have before us, if the closing had occurred after July 1, based on my interpretation of the statute, the exemption would have carried into for the complete year of 2019. So on January 1, 2020, so on January 1, 2019, we had property that was exempt. It lost that exemption because of the closing that occurred before July 1, 2019. But the county did approve the year 2020 tax exemption. So on January 1, 2020, the property was in exempt status again. During the period of the appellate's ownership of the property during the 2019 calendar year, the property was continually used for religious purposes and qualifies as exempt under 105-278.3 and 105-278.5. The appellate did not receive mailings from the county due to the incorrect address on the deed conveying the property to the appellate. The county is not under obligation to send notice to the property owner, but they did. The appellate did not receive the information, did not become aware, or they did not receive the mailings from the county in calendar year 2019 and did not become aware of the exemption being removed until 2019 had expired. So the appellate in this case, Mr. Chairman and Commission, is requesting that the Commission, in its capacity as the State Board of Equalization Review, grant the 2019 application for exemption that was not accepted by the county. And we have an issue with this case, Mr. Chairman, that this is not a direct appeal from the county, the Wake County Board of Equalization and Review. And it's not an appeal from an action by the Wake County Board of Commissioners. The county tax administrator would not accept the 2019 application in January of 2020. The tax administrator gave recommendation to the appellate on what to do, and they followed that recommendation by filing an appeal with this commission. So the appellate never received notice of the removal of the exception within the time frame to file an appeal under 105 105-282.1A1. But there's also, Mr. Chair, when looking at 105-282.1 subsection C, it's entitled Discovery of Property. And what this provision states is that when an owner of property that may be eligible for exemption or exclusion neither lists the property nor files an application for exemption or exclusion, the assessor or the Department of Revenue, as appropriate, shall proceed to discover the property. If upon appeal, the owner demonstrates that the property meets the conditions for exemption or exclusion, the body hearing the appeal may approve the exemption or exclusion. Discovery of the property by the department or the county shall automatically constitute a discovery by any taxing unit in which the property has a taxable status. So, Mr. Chairman and Commission, again, the appellate did not receive notice that were sent to the wrong address. They never received notice. They were not aware of the requirement to file the application. The property had been used for, when they purchased the property in the years preceding that, it had been used by a church for a church. And they continue to do that. And also, Mr. Chairman, we have two final decisions by this commission from a few years ago. One has a file number 09 PTC 783. And that is entitled In the Appeal of Summit and Evangelical Covenant Church, FKA Redeemer Covenant Church. And also, Mr. Chairman and Commission, there is a decision by this body under file number 10 PTC 147 entitled In the Matter of the Appeal of Congregation Sharia Shalom. While these cases are not exactly on point with what the facts we have before us, they're very similar. In both situations, we're dealing with churches. In both situations, Mr. Chairman, it's a Wake County case. In both situations, in the findings of fact and the final decision, the commission found that the appellate had not received an opportunity to file the appeal because they did not have the notice. They were not notified of the requirement of the need to do that. And in both of those cases, as a matter of law, the commission found that it has the discretion. Well, in 09 PT 783, the Summit case, as a matter of law, the commission found that it had the discretion upon a showing of good cause to approve a late application for property tax exemption. It also found that the appellate did not receive notice of the requirement to file the application for exemption. So both of these final decisions, Mr. Chairman, are germane and I think to a large degree on point with the facts circumstances we have before us, which is the property that is at issue for years had been used by a church, for a church. A church purchased the property due to the fact that the closing attorney entered an incorrect address on the deed. The notices, including the 2019 year tax bill, was mailed by the county, but not received by the appellate. The appellate became aware of the removal of the exemption after 2019, in January of 2020. So they did not have notice of the issue until after, under the statute, they could have applied for a late application. So we ask, Mr. Chairman, this commission to, first of all, would ask that it grant, we believe that as the The appellate's position is that Property Tax Commission, as the State Board of Equalization and Review, has the necessary authority to grant the 2019 exempt tax application. We also believe, and our position is, Mr. Chairman, that under North Carolina General Statute 105-282.1C, that this can be viewed as discovered property. And under that statute, as I read earlier, there's no distinction made about whether or not an appeal, what body hears the appeal. It just states that the body hearing the appeal may approve the exemption or exclusion. So we think that is applicable to this set of facts. And in the alternative, Mr. Chairman, we would ask the Commission to order Wake County to receive the 2019 application and to receive that and allow it to be processed, because it's undisputed fact. There is no dispute that the property was qualified for exemption, and Ken, Mr. Murphy will need to speak to this, but it would be our position that if the appellant had filed the application before the end of 2019, that it would most likely have been granted by the county. So it's an unfortunate set of circumstances, but at the end of the day, we've got a bad address on the deed that led to the appellant not receiving notices that the county was sending them. When they became aware of it, they took action, and that's why we're here today. And I apologize, I'm having a very hard time. I have a lot of feedback. I hope that was clear.
It is clear here, so I'm sorry you're getting feedback. You get the feedback when I talk, or when you tell?
When I talk.
When you talk, okay. All right, let's hear from Mr. Murphy as to what the Wake County's intentions are in this case. Murphy?
Thank you, Mr. Chair. Good afternoon, Mr. Chair. Good afternoon, Commission member. It's a pleasure to be before you again, albeit virtually. And Mr. Adcock gave a very thorough and accurate recitation of the facts. As he stated at the outset, the parties have stipulated to those facts, and there really are no facts in dispute in this matter. Can you all hear okay?
We can.
Okay, good. Like Mr. Adcock, I'm getting feedback when I speak, but as long as you can hear me, it's not a problem. Mr. Chairman, Commission members, as far as the county is concerned, the only issue in this appeal is the fact that the exempt application for tax year 2019 was not submitted until January of 2020. So it was submitted, the exempt application for tax year 2019 was submitted after the end of the calendar year of 2019. And Mr. Adcock touched on the controlling statute, which is NCGS 105-282.1A1. And the county's contention is that that statute is very clear that a county may not receive an exempt application for tax year after the last calendar day of that tax year. And that is exactly the situation that we find ourselves in with this appeal. The church through no fault of its own, did not submit the exempt application for 2019 until the end of January 2020. So again, it's the county's contention that the county was prohibited by statute from accepting that exempt application for 2019. With respect to I would note for the commission that General Statute 105-348 charges owners of real property with notice of their property tax obligations, regardless of whether they receive actual notice or not. And I would also note for the commission, and again, Mr. Adcock did touch on this, that when his client purchased the property in May of 2019, the county sent an exempt application, or tried to send an exempt application to his client. And through no fault of the county's, that exempt application did not make its way to his client because of the incorrect address on the deed. But I would note for the commission that the county was not obligated to do that. The county did it anyway in a good faith effort to make the new owner of the property aware of their obligation to file an exempt application before the end of 2019. Mr. Adcock mentioned another statute, 105-282.1C, and the county would contend that that statute, you have to read that section of 105-282.1 parallel with the earlier provision of 105-282.1, 105-282.1A1, that prohibits a county from accepting an exempt application for tax year 2019 after the end of calendar year 2019. And the county would contend that 105-282.1C was followed here. The county did discover that property when it did not receive an exempt application for it. But again, there could be no appeal because the exempt application, when it was eventually received, was not received until after the end of calendar year 2019. Now, in candor to the tribunal, Mr. Adcock mentioned the two previous decisions of this commission on similar facts, where a religious institution in both cases submitted an exempt application for exemption from a tax year after the end of that calendar year, of that tax year, and this commission directed the county to accept that application and grant that exemption. Again, the county would contend that those were incorrect decisions by this commission, and the county would point out to the commission that those are not binding. They have no precedential effect. The county has been unable to find any appellate decisions that would support either of the conclusion and the direction of the commission in those two cases. But again, with candor to this tribunal, those previous decisions of this commission are out there, and the county does acknowledge that. And Mr. Adcock was absolutely correct in bringing that to the commission's attention. So in closing, The county contends that General Statute 105-282.1A1 control, and on this unfortunate set of facts, prohibits the county from accepting the exempt application from Mr. Adcock's client for tax year 2019. However, the county does acknowledge the commission has seen fit to rule contrary to that in the past on similar facts.
All right, well, both of y'all laid this thing out for us, I think, extremely well. I do have one thing I want to ask about that was not covered, and that is under 105-282.12. Well, it's not A, it's 4A. Where does it say in there that after that first application is approved, seems to me, as I read it, it says an owner of one or more of the following properties eligible for the property tax benefit must file an application for the benefit received. Once the application has been approved, the owner does not need to file an application in subsequent years unless new additional property is required or approved. Once are added or removed, necessitating a change in the valuation of the property, or there's a change in the use of the property, or qualifications or eligibility of the taxpayer, necessitating a review of the property. And those properties are, and it includes 105-278.3. So what triggers that there has to be a new application filed? It's certainly not under that section as I read it. Mr. Adcock, you want to speak first? And Mr. Murphy is.
I really tell you, I had a difficult time ascertaining everything that you were speaking in regards to, but if I understood correctly, the question is dealing with why would my client be required to file an exempt application? Is that the question?
Yes, under 105-282.1, where it says single application required. I think you get it. It lists certain things where you have to apply. If they happen, none of which it appears applies here. Is there another statute that controls about why the new owner is still entitled to the exemption, still about has to file another application?
I believe, Mr. Chairman, and Mr. Murphy, please tell me how you think about this, but the statute you're referring to, I believe, is based on the ownership of the property. That is, if the ownership changes, the property itself, it's not based on perhaps the use of the property, but the ownership changes triggers the requirement for a new application. When I refer to 105-285, Section D, it states that the value of real property shall be determined as of January 1 of the years prescribed by DS 105-286 and 287. And this is the point I'm going to make. The ownership of real property shall be determined annually as of January 1, except in the following situation: when any real property is acquired after January 1, but prior to July 1, and the property was not subject to taxation on January 1 on account of its exempt status, it shall be listed for taxation by the transferee as of the date of acquisition and shall be appraised in accordance with its true value as of January 1 preceding the date of acquisition, and the property shall be taxed for the fiscal year of the taxing unit beginning on July 1 of the year in which it is acquired. So, Mr. Chairman, my interpretation of that is that if a property is exempt status on January 1, and under the facts we have before us, it was, the ownership changed prior to July 1. Therefore, the exemption for that year is lost without the new transferee applying for exempt status. versus if in this situation, if my client had not closed on May 20th, but it closed on July 2nd, the exemption would have carried through for the entire 2019 year. So that July 1st is a critical date from the standpoint of the imposition of these statutes. And that would be my interpretation. That is what triggered the requirement for a new application.
And I underlined that we mentioned it earlier, and I was aware that it seems like certainly under 105-282.1, 2, is not required, and I understand what you're saying about 105-285.d, although it seems like a little higher. I don't know. Mr. Murphy, I assume you would cite the same statute for that proposition.
Yes, sir, Mr. Chair, and I would point out to the commission that, Mr. Chair, the statute that you were citing in your question to Mr. Adcock, 105-282.1A2, I believe that the intent of that statute is to indicate that the owner, like when a person or when an entity owns property that is wholly and exclusively used for religious purposes, they only need apply one time for the exemption, as long as that entity continues to own the property. You know, meaning they don't need to apply each year for a new exemption. I think that is the thrust of that statute. As Mr. Adcock noted, if that property changes hands, if it is sold, then the new owner does need to apply for the exemption if they have grounds to do so. But I think that the main intent of that statute that you cited, Mr. Chair, was to indicate that it's not something that the owner of religious property needs to do yearly. They only need to apply for the exemption once, unless a disqualifying event happens, you know, such as the sale of that property to another entity or another individual.
Well, let me ask you this: without there being 105-285D, you did not have that section. You just looked at 105-282.1, 2. It says an owner and the owner. Certainly, someone could argue that that doesn't require a new application on its own, unless one of those changes listed occurred. But anyway, all right, this, I don't know that probably other commissioners got questions. We haven't seen those two cases. Do either one of you have those cases to submit, or do you have those cases? Questions, Commissioner?
Mr. Murphy, when is the listing period right now?
The listing period ends on January 31st of the calendar year for which the exemption is sought. So for 2019, tax year 2019, the listing period would have ended on January 31st, 2019. And that is where the 105-282.1A1 provisions for making a late application for exemption come into play. You know, the county's contention is that it's appropriate for a late application to be considered and to be granted if the applicant can show good cause, if that application is submitted between February 1st, December 1st. of the tax year for which it is sought. Does that answer your question?
Well, yes. I know January 31st is my fault, but when the former church owned it, that listing period was in place. So that application for 2019 follows through and is automatically exempt for 2019. I realized that in May of 19, it changed ownership. The problem I have is if you're going to file an application for exemption, the new church, you have to do it. It says the last sentence in A1, you must do it during the listing period. The first available listing period is January 31st, 2020. Do you follow me?
I am not sure I heard everything you said. If I understood you correctly, your question is when the property is conveyed after the end of the listing period, which it was here in 2019, and then I lost you after that. I'm so sorry. Could you tell me what your question was after that?
I'm not trying to make a point here. I'm trying to ask a question. When the new owner took over in May of 2019, it's my understanding that
listing period. The next available listing period is not until January of 2020. Because the listing period for 2019 is already gone. So I'm not sure the application was late. If they must file that, I don't know where you got December 31st from. You're saying an application in this instance has to be filed before December 31st. When it says that the application must be filed during the listing period, which to me is January 31, 2020.
Commissioner, I hear you. I would contend that the statute is plain that the end of the listing period for tax year 2019 is January 31st, 2019. And then the application would be considered late if it were filed between January 31st, 2019 and December 31st, 2019.
But the purpose of me asking you the question of when the listing period was, your answer was in January of the fiscal year.
I think we have to look at the last sentence of 282.1A1. An untimely application for exemption or exclusion approved under this applies only to property taxes levied by the county in the calendar year in which the untimely application is filed. So that there would have been taxes levied for tax 2019, and that would mean that the application for exemption would need to be filed by the end of the calendar year 2019. That's the county's interpretation of that statute.
I hear you. Well, I just contend that it doesn't end until January 31, 2020. you have until the next listing period. Because the listing period for 2019 is gone.
Which statute were you using, Commissioner Williams?
282(1)A, the last sentence,
282(1)A,
application.
.1A? I'm missing where you are, I guess.
282.1A,
Oh, I got you, okay.
application, the last sentence. The second paragraph, I'm sorry.
Okay, I got you now. I couldn't find it. Now I've got you. All right.
An owner claiming an exemption from property taxes must file during the listing period. You answered the question that the listing period is in January, which is what I thought it was.
So
And
technically,
they couldn't file it in January of 2019 because they didn't own it.
it was already exempt.
Yes.
You through?
Yes.
Commissioner Guest?
Mr. Murphy, question for you. Is there any place in the statute that says when a new owner takes possession of property, okay, that they have a time period, 30 days, 60 days, 90 days, something along this lines, to make application to continue the exemption? Now, I know that in, say, forestry exemption, if you have a present use value forestry exemption or agriculture exemption, and you take over property, you have a time period to make an application. And after the 90 days or whatever the time period is, you're late, right? Is there anywhere here that states that they have a time period other than under 105, 282, 1A1, where it just says by the calendar year, meaning December 31st?
Commissioner, there is not. The closest thing that I'm aware of is General Statute 105-285D, and Mr. Adcock referred to this statute, and it says essentially that when real property is acquired after January 1st, but prior to July 1st, and the property was exempt as of January 1st, it shall be listed by the transferee as of the date of acquisition. So here, the date of acquisition was May of 2019, and it was incumbent upon the new owner of the property to list the property, or in this case, to seek exempt, submit an application for exemption for that property, between May 2019 and the end of December 2019.
What does it say then? I think that's all.
I think that's Alex's question. Where does it say that you have until December 31st?
105-281.1A1, or excuse me, 282.1A1. I'm sorry for the court order. I don't want to mess up the transcript. It's the county's contention that the plain language of that statute requires the exempt application to be submitted by the end of the calendar year for which year taxes are levied by the county. So in this case, that would be December 31st, 2019.
Further question, Mr. Guest or Ms. Wheeler? Let me ask this. It seems like we need to look at those two cases, and I don't know that we need to take everybody's time. Yes, Ms. Wheeler.
Okay, now I think it's working. Would either of you care to opine on the public policy reason behind the last sentence of 105, 282.1A1, limiting it to filing the untimely application during that calendar year? Any thoughts on why the legislature would put that in there?
Yes, Commissioner, I'll take that first. I think the public policy reasoning is pretty clear. Counties and municipalities need to know for budgeting purposes what their tax base is. And if you allow exempt applications for tax years to be filed after the end of that calendar year, after budgets have already been set, it could really hamper local government's ability to budget correctly and responsibly. Now, that being said, I realize that's not as much of an issue in the case that is presently before the commission. But I think that's the public policy reason for the legislature writing that statute the way it did.
All right, let me ask the commissioners. Oh, I'm sorry. All right, Mr. Adcock, you want to respond? You have to unmute. You need to unmute. Now you go. There you go.
Okay.
There we have you. Thank you.
Can you hear me?
We can.
Mr. Chairman, thank you. I do not disagree with Mr. Murphy's position on that. I don't know what the intent of the General Assembly was with that specific statement. I will say that, to my knowledge, the county operates on a fiscal year that commences on July 1 of each year. So they're even though we, I have a real estate practice, law practice. So we prorate taxes based on the calendar year. But the county actually makes its budget based on a fiscal year commencing on July 1 of each year. Again, I'm not here to second guess what the General Assembly was indicating here, but the fact is that the county's budget begins on July 1, not January 1.
All right. Thank you. Anything else y'all want to say before?
I would like one thing, Mr. Chairman.
Mr. Adcock.
I just again want to point out this discovery of property provision in 105 282.1 subsection C. It just with the facts not being disputed here, it seems that this provision itself allows this body to act and to grant this application. And also based on the two prior cases that we referred to that this commission has made decisions in previously. And I appreciate the time to be before you, and my client is very grateful for you allowing the opportunity to be heard on this matter. Thank you.
Mr. Murphy. Now I think we have a question.
Thank you, Mr. Chair. I have nothing further from the county, but happy to answer any question that a commission member may have.
Now I think from what I heard you say, you agree with Mr. Adcock that there is precedent for the commission doing this, even though you're not saying that you agree with that precedent. And I take it also that without that last sentence in 105-282.1, you would have no problem with the exemption being applicable to the year 2019. Are those proper statements?
Yes, you are correct on both counts. I do agree with Mr. Adcock that there is precedent, although not binding, as you indicated, for this type of thing. And I do agree that but for the last sentence of 105-282.1A1, the facts that have been to here would certainly amount to good cause. And so yes, I agree, Mr. Chair, on both counts of what you just said.
Okay, let me see if there are other questions. Yes, Mr. Guest.
Mr. Murphy, Alex Guess here. So going back on what Mr. Adcock was just talking about, under 105-282 1A1, the last paragraph reads, an untimely application for exemption or exclusion approved under this subsection applies only to property taxes levied by the county or municipality in the calendar year in which the untimely application is filed. Now, if we then jump to 105-282 1C, in the middle of the paragraph, it reads, if upon appeal, the owner demonstrates that the property meets the conditions for exemption or exclusion, the body hearing the appeal may approve the exemption or exclusion. All right, taking those two together, I believe that the county's position is this would apply to a late application, which you state is a application made after January 31st, 2019 and before December 31st, 2019. And it would not matter that the hearing, our body was hearing this in 2020, that it would not apply because the late application was not made during calendar year 2019. Is that's how you're indicating these?
Yes, that's correct. I think I understood what you said, Commissioner Guess. Let me test my assumption though. Did you mean that if the application for exemption had been filed before the end of calendar year 2019, in this case, that this commission could have heard the appeal, even though it's obviously 2020 now and not 2019, and the commission could have found good cause for the late filing of the application had it been filed before the end of December 2019. Your guess is
That's
that what
correct.
you're asking? Yes, I do agree
Yes.
with that.
Okay. Now the same question goes to Mr. Adcock. Mr. Adcock, having read this, the county's position is that 105-282 1C, that our ability to grant a late application does not apply because the application was not made before December 31st, 2019. Tell us why you believe under 105-282 1C, we can still grant that.
Thank you, Mr. Guest. I disagree with Mr. Murphy's position on that. I do not see limiting language in subsection C that I'm referring to that references calendar year or any time frame. It simply states that there are two conditions when an owner of the property may be eligible, neither lists the property, which is the case here, nor files an application for exemption for exclusion. The Accessory Department of Revenue shall proceed to discover the property. I would suggest to you that's what happened here. The property was discovered for taxation. And then again, there's no reference to a timeline, deadlines. It just states if that occurs and upon an appeal, which it doesn't state which body must be the appellate body, if the owner demonstrates it meets the conditions for exemption, the body may approve the exemption. So I don't see the correlation between A1, the last sentence of A1, and subsection C. I believe the appellate's position would be that subsection C stand on its own legs. There is no stated timeline where there is in A1.
Okay, thank you. And one final question from Mr. Murphy. Mr. Murphy, did you state earlier that it is correct that the county did discover the property because it was not listed?
Yes, that is correct.
Thank you.
All right, other questions? All right, let's do this. We need to look at those opinions, I think, and see what the precedent is. So rather than keep y'all online, we'll get those opinions and we'll deliberate, and then we'll notify you of our decision and then follow it up with an opinion. Is that okay with the commission? Okay. All right. Y'all did a great job in laying it out there, and it's just that we've got statutes that here that could be considered as maybe having different impacts and effects and conflict, but we'll see what we can work out. And again, y'all did an excellent job, and thank you so much. We'll try to have you an oral opinion probably by the end of the week. If we can't, we'll probably let you know on that as well. And then a written opinion would follow up sometime later. Thank you very much. Is there anything else that we need to be on the record for Mrs. Garrett to remain on, Mr. Pelfrey?
No, sir, there's nothing more for the record today.
All right, Ms. Garrett, it's great seeing you back. We will see you in the morning. Let's see, Mr. Murphy, do you have anything else? I don't think there's anything else from Wake County before us this week, is there?
Sir, there's not, Mr. Chair.
All right. Well, we'll probably see you before too long. Thank you. Thank you all so much.
Thank you, Mr. Chair. Thank you, Commission members. Thank you, John.
We'll go off the record now. Thank y'all.
Thank you.
As soon as you're off, then we'll